Question 535. Tenant Charles notifies owner Sam that Charles surrenders his lease to a unit in a commercial building. Sam has the legal right to do which of the following? A. Signal his acceptance of the surrender by changing the locks on the door. B. Enforce the lease and continue to pursue rent payments from the lessor. C. Both A and B. D. Neither A nor B. Correct answer is C. The surrender of a lease terminates the lease agreement and concludes the tenant-landlord relationship as long as the landlord completely agrees. Question 536. The following would probably result in the greatest increase in home buying. A. Higher interest rates. B. Lower interest rates. C. Greater supply of housing. D. Decreased supply of housing. Correct answer is B. Providing consumers with cheaper borrowing costs is most likely to raise the number of homes purchased. Question 537. Grown siblings can take title to property as A. Tenants in common. B. Community property. C. Joint tenants. D. Both A and C. Correct answer is D. Siblings, brothers and sisters, can take title in almost any legal form except community property, reserved for spouses. Question 538. If a veteran purchases a home under the Calvet program, the grant deed is executed under the name of the A. California Department of Veterans Affairs. B. The lender for the loan. C. The title company. D. The veteran. Correct answer is A. Calvet Sales employ a land sales contract with the California Department of Veterans Affairs as the seller, vendor. Question 539. A prospective borrower applies for a loan to buy a property in a poor neighborhood. Although the loan applicant has excellent credit scores and a steady income, and the property has excellent potential for renovation, the local lender turns down the loan app. The lender is probably A. Justified, because the property is in a disadvantaged neighborhood. B. In violation of the Rumford Act. C. In violation of the Holden Act. D. Likely to have its license revoked by the controller of the currency. Correct answer is C. Under California's Holden Act, the lender must make lending decisions based on the worthiness of the borrower and the security property, not on the property being in a certain neighborhood. It is against public policy to refuse mortgage loans or to impose stricter loan terms due to neighborhood characteristics. Another state law, the Rumford Act, prohibits discrimination based on the applicant's race, color, religion, gender, sexual orientation, and other protected groups. Question 540. Which of the following kinds of deed carries no warranties of title? A. Quitclaim deed. B. Trust deed. C. Sheriff's deed. D. Both A and C. Correct answer is D. A quitclaim deed is used to correct a technical flaw in an earlier deed or clear a cloud on title. It is often referred to as a reformation deed. This kind of deed is used when the grantor is unsure of the validity of his title and does not want to provide warranties. A court-ordered sale of property is executed through a sheriff's deed, which also carries no warranties of title. Question 541. On a construction loan, the lender's last payment usually will not be made until A. The building is completed. B. After the expiration of the lien period. C. The close of escrow. D. It is listed by a broker. Correct answer is B. For general contractors, mechanics liens must be filed within 60 days of the filing of a notice of completion and within 90 days if no notice is filed. Lenders like to wait until such lien rights have passed before releasing the final payment. Question 542. Homestead protection can be terminated in all the following ways, except A. If the homestead is sold. B. If a creditor brings a legal action against the homesteader in bankruptcy court. C. If the homesteader files a declaration of abandonment. D. If the homesteader files a declaration of homestead on another property. Correct answer is B. Homestead laws are favored by law and custom and are favorably construed to protect the homestead. Once a homestead is established, it is presumed to continue until terminated. Question 543. A real estate agency would not terminate if a. the principal revokes the agency on his own accord, b. the property that is the subject of the agency is destroyed in a fire, c. the principal is killed, d. the principal fails to accept an offer brought to him by the agent within the allotted time period to decide, terminating the offer. Correct answer is d. The termination of an offer does not, in itself, terminate the agency between the principal and agent. Question 544. Which of the following is a kind of promissory note? A. Straight note. B. Fixed-term note. C. Installment notes. D. Both A and C. Correct answer is D. The borrower signs a promissory note, or note, as it is sometimes referred to, when a loan is made. This note states that a certain amount of money is borrowed on a promise of repayment. The promissory note thus becomes an evidence of the debt. The borrower is referred to as a maker, and the lender is referred to as a payee. Question 545. Once a tenant has vacated leased premises, his security deposit should be returned by the landlord in A. 10 days, B. 21 days, C. 1 month, D. There is no deadline for returning the deposit. Correct answer is B. If the deposit, or portion of the deposit, is not returned, the landlord must send the ex-tenant a written explanation as to why. Question 546. All listings, deposit receipts, and trust account records must be retained by a real estate broker for A. 2 years, B. 5 years, C. 10 years, D. None of the above. Correct answer is D. Most records dealing with real estate brokerage must be kept for 3 years, except those relating to mortgage loan or securities brokerage, which must be held onto for 4 years.